cultural and moral and religious backgrounds that we bring to the practice of medicine. Right, so just as an example, consider this kind of scenario. Consider Dr. X has strong moral convictions based on maybe her religion, personal philosophy, her cultural norms and backgrounds, the professional ethical codes of the professional organizations that she subscribes to or identifies with. So that Dr. X, based on these things, believes that a LGBT patient or a person who's a terrorist or enemy combatant or someone with a particular illness or a patient who's terminally ill shouldn't be evaluated or told about certain treatments or given certain treatments for the condition or given a lethal medicine with the intention of dying from it. In fact, so strong are those convictions that Dr. X believes it is unacceptable to even be part of the chain of referral to another physician. That would be an act of moral culpability. All right, let's take a look at sort of how this has played out in the recent history of United States healthcare by beginning to look at some of the ways this has come up in policy and law in our country. There are many issues that clinical issues that this has swirled around: abortion, LGBT issues, reproductive rights, withholding and withdrawing treatment or assisted suicide and euthanasia, doctors participating in legal execution and torture, or whether we will engage in civil disobedience and override the various gag orders that different jurisdictions have put on us in restraining our communications with patients. We really go back to 1973. The United States actually, as back to James Madison, as a country whose origins are grounded in conscience, indeed, conscientious objection to the British Crown and some of its principles, and taxes without representation and so forth. We actually have a history of some conscience protections, in particular, some protections of conscience in the arena of healthcare. In 1973, the Church amendments to the federal code allowed certain federally funded physicians, nurses, and hospitals to refuse to perform abortions or sterilizations based on religious and moral convictions. In 1996, the Coates Amendment to the same federal statutes dealt with medical education, allowing physicians and students to abstain from abortion training, and that you could still maintain accreditation of your residency, even if you refused to provide abortion training. 1997, the Balanced Budget Act allowed insurance companies to deny coverage and reimbursement and even referrals on the basis of religion or moral conviction. 2005, the Weldon Amendment allowed forbidding funding to any institution in healthcare that discriminates against those who refuse to perform or refer to or cover abortion services. In 2009, the Bush administration gave extensive provider conscience regulation that protected a person from mandatory participation in any treatment or research contrary to his or her religious beliefs or moral conviction. The Obama administration, although they embraced that legacy, they actually curtailed the provision, so it made it very specific to abortion, the protection of those who refuse to participate in just abortion and sterilization. So in the Affordable Care Act, so-called Obamacare, however, they felt it necessary to protect patients from conscientious objecting physicians, making it unlawful to refuse to treat an individual or otherwise discriminate on the basis of race, color, national origin, sex, or disability. Now, those are pretty general rubrics, but the courts subsequently interpreted this section of the Affordable Care Act as protecting patients to not be discriminated against for seeking treatment for sexual preference, transgender, or abortion. And at this point, there actually are conscience clauses that actually do favor, or at least protect some aspects of physician or healthcare conscientious objection if they refuse to participate in abortion, sterilization, and emergency contraception in most states. However, there are 13 states, though, that have specific statutes that say you cannot engage in conscientious refusals for abortion in particular. They've singled out that particular practice if a mother's life is in danger. They felt a need to carve out the emergency situation so that conscientious objection not be a carte blanche. All right, now what do various healthcare organizations have to say? You know, the fact of the matter is at this point, the legacy of medical ethics and the principles of medical ethics are being the stewardship over both maintaining those as well as refining them and developing them and crafting them really now lies in the hands of professional organizations that have codes of ethics like the AMA and the APA and these various other organizations. So let's see what healthcare organizations have to say about this. So the AMA Principles of Ethics, that code of ethics, to which, by the way, the APA subscribes, our code of ethics and the APA are called the American Medical Association's Principles of Medical Ethics with annotations particular to psychiatry. So we actually build our code of ethics on the AMA code in psychiatry. But Section 6 says a physician shall, in the provision of appropriate patient care, except in emergencies, be free to choose whom to serve, with whom to associate, and the environment in which to provide medical care. So that's an overarching notion. And then in the opinions that further explicate underneath that section what more specific circumstances, the AMA has said this permits physicians to refuse to treat patients who are seeking care that is, quote, incompatible with the physician's deeply held personal, religious, or moral beliefs. And in another place, an opinion says of the AMA, physicians should have considerable latitude to practice in accord with well-considered, deeply held beliefs. The American College of OBGYN has a whole specific ethics committee opinion on the conscientious objection. They actually say that conscientious objection should be allowed, but within certain limits. That if you want to refrain from certain practices, and obviously in the case of ACOG, they're primarily thinking about reproductive things like abortion, sterilization, and the like. It says they must provide patients with a prior notice, that they have a duty to refer. We're going to come back to this duty to refer. That they have to practice, you should be practicing if you have a strong moral objection in proximity to other practitioners who don't share your beliefs, so that if you don't want to perform a certain procedure, you have somebody to whom you can refer. And the standard exculpation, which is an emergency, you have an obligation to go in and minister to the patient in life-saving circumstances, no matter what your principles. Now, the American Psychological Association, interestingly, as when they address this, they actually sound like mental health professionals. They say psychologists should engage in personal introspection, training, supervision, and consultation to help them integrate their personal beliefs with their ability to provide competent care. The goal should be developing competence rather than from escaping from uncomfortable situations. So we in psychiatry can easily translate this into saying, you know, all right, conscientious objection is something we should respect, but let's be careful here that we not overplay this, and that we be sensitive to this as a counter-transference issue that may have to do with certain unhealthy or ill-considered obstacles to our own personal reflection. So they are a little bit less clear in the support of conscientious objection. Again, thinking psychologically about it. The nurses, American Nurses Association says that a nurse is justified in refusing to participate on moral grounds in some procedures, but that conscience-based refusals should exclude personal preference and prejudice and bias and convenience or arbitrariness. And this is, one of the challenges, and that is what to one person seems like, a deeply considered, reflective, informed system of values. To another person on the outside may appear, or at least be potentially invalidated as a personal preference or a prejudice or a bias. By the way, they add that acts of conscientious objection are acts of moral courage and may not insulate nurses from formal or informal consequences. So they're just putting the nurses on notice that you can be courageous and stand up, but don't expect necessarily that that's going to protect you from professional or legal consequences. The American Pharmacists Association recognizes the individual pharmacist's right to exercise conscientious refusal. And this is important. You might ask, well, where does this come up for pharmacists? It comes up for pharmacists perhaps in dispensing abortifacients for morning after pills, and especially now in the 9 states that allow physician-assisted suicide, refusing to dispense medications designed to kill the patient. Right, so let's look at some of the ways that there have been struggles in this country over some of these protections that the government has provided for practitioners as well as patients. So remember this, the Affordable Care Act and its protection of patients, and interpreted in these ways. Well, that particular provision actually was blocked by 2017. It originally came up in 2010 by a US district court, where the judge found that that there is a problem with violating the religious freedom of doctors. If you forbid doctors from engaging in those kind of conscientious objections, that you may be interfering with religious freedom, and insurance companies as well that may consider things like gender transition and abortion to be, quote, evil. So there was a legal challenge to that that blocked that. Under the Obama administration, the Department of Health and Human Services came up with a document called Conscience Protection for Healthcare Providers, in which they said that they want to promote the protection of healthcare providers who refuse to participate in certain things on religious and moral grounds, and said that they established a system to file a complaint with federal authorities if you believe you've been discriminated against by your institution because you refuse to participate in medical procedures like abortion or sterilization, or were coerced into performing procedures, and especially they had a specific provision that identified the area of assisted suicide or euthanasia for physicians that felt that they were being pushed or intimidated by their institutions in those states that have been started to allow those practices. Well,
I'm sorry, can I ask a quick question? Is that all right?
Okay.
Sorry, about your previous slide about the federal court decision.
Yeah.
I was just wondering, because clearly there's a difference between conscientious objection to certain procedures versus conscientious objection to treating certain types of patients. And this one sounds like it upheld the right to not treat certain types of patients, not just do certain procedures. Is that right?
No, this was about procedures. This was about participating in gender reassignment surgery and abortion.
Okay, so the headline was a little bit misleading. Yeah.
It is. Yeah, you're right. The headline, which is the Slate headline. Very good. Thank you for pointing that out. That definitely the headline is incorrect in that. Thank you very much. So this particular document was also overturned in federal court, where a judge voided this so-called conscience rule. And again, this is focused, as you see in the text here from the New York Times, got it right, on medical procedures. So the Trump administration found an alternative route. The alternative route, they set up a new division. There's a whole new division now, as opposed to a document. And the division is the Conscience and Religious Freedom Division. In its director, whose name is Severino, said no one should be forced to choose between helping sick people and living by one's deepest moral or religious convictions. For too long, governments, big and small, have treated conscience claims with hostility instead of protection. But change is coming, and it begins here and now with the establishment of this new subsection of HHS that was going to identify and help defend doctors against action by their institutions. And they promulgated another attempt. They promulgated a new rule. In May of 2019, this particular rule that of HHS to protect a broad range of entities that might be engaged in providing coverage and services subject to discrimination, for protecting them if they refuse to provide or cover abortion and assisted suicide. That was one clause, but the rest of the document goes on and mentions also sterilization and gender reassignment procedures. So there was a tremendous outcry about that. The Trump administration agreed to delay the ruling for a while and postpone this particular rule until, and because the challengers were taking it to federal court. And so there was an injunction put on the deployment of the rule, and the court was expected to rule on November 22nd of 2019. But a little bit earlier than that, the federal judge, Paul Engelmeyer, basically ruled against this and said that the federal government was exceeding its authority, was acting arbitrarily and capriciously in promoting it, and he vacated the rule entirely 2 weeks before they had planned for it to take effect. Judge Paul Engelmeyer is up there in New York, and on a little personal note, Paul Engelmeyer is actually my parents' godson, so sort of a ersatz member of our family. So that was an interesting moment for us personally in our family. Now, with all of this talk about religious freedom to be engaged in conscientious objection, I want to point out that in the state of Oregon, I pick Oregon because that is the Serengeti Valley of physician-assisted suicide, the first state to craft it, to deploy it, and the state that has had the most number of patients die on the basis of physician prescriptions deliberately designed to cause death. In Oregon, 40% of all hospitals are Catholic. Object to that practice as well as to abortions and sterilization procedures. And in some areas, because it's a really rather rural state, there are no other options for care than Catholic hospitals. In the United States, 17% of all hospitals are Catholic. In this particular case, Minton versus Dignity Health, there was a Catholic hospital that refused this patient a hysterectomy as part of a sexual reassignment surgery, and the patient sued the hospital. And the California Court of Appeals found the patient's right to full and equal access to medical treatment is more compelling than protecting the hospital's freedom of religion. So this conscientious objection case on the part of an institution was litigated and found in favor of the patient's rights to access rather than the institution, the Catholic institution's right to access. In this New England Journal article, these two people, including Thaddeus Pope, a very well-known healthcare legal scholar, talked about when religious institutions and secular institutions merge, as happening increasingly as healthcare institutions merge. And they make an argument in this article that when such mergers occur, the merger should retain the scope of services formally offered by the secular hospital, not the religious one. So the broader access and the most expansive list of acceptable procedures should be the dominant one in such a hybrid system. And you can read that article if you want to penetrate their arguments. Now, I want to just touch on a couple of other kinds of controversies in healthcare conscientious objection, and that is so-called tell and gag laws. Some laws that required physicians to say certain things to patients, and other laws that require them to not say certain things to patients. For example, this issue about the reversal of abortion. North Dakota, Arkansas, Idaho, South Dakota, and Utah all have enacted laws that force doctors to tell patients that medication-induced abortions may be reversible, which, by the way, is a claim that is unsupported by reliable scientific evidence. And not only do you have to tell the patient what we're doing now might be reversible when there's no credible evidence to support that, you're also required to tell them that abortion, quote, and you must say these words, it terminates the life of a whole, separate, unique, living human being, unquote. So the American Medical Association sued North Dakota after they passed that law, and they sued it successfully, and the law was declared unconstitutional. Then there's another law, that Trump's Title 10 law, that is also a gag rule that talks about what physicians must and must not say in the course of engaging in family planning. And this was a federal law. And the AMA sued against that, and a judge ruled in favor of the AMA in June 2019. Our APA has a similar position to the AMA. Here is one of our official positions, 2018. That says requiring physicians who are counseling and treating pregnant women to follow specific scripts represents an unprecedented effort by the government to intrude into the privacy of physician-patient communications. In Florida, the House of Representatives passed briefly a law that gags physicians from inquiring about firearm possession unless that information is relevant to the patient's medical care, and you have to have very, very strict criteria for determining whether or not it is relevant to a patient's medical care that were very carefully laid out. Well, ultimately, a court struck that down, and they lifted that particular gag order in February of 2017. In our own profession, it's interesting, there are actually no specific laws in any, either at the federal level or state level, outline the provision of one of our procedures, which is ECT. But unlike any other procedure in psychiatry, there are a number of states that have statutory regulations about this procedure, and only this procedure, in our armamentarium. These statutory, and here there are examples, you can't read them on the right, and it's not important at the moment, but they talk about who can receive ECT, what ages are eligible and not eligible, who must provide informed consent, who can perform the ECT, what are the special reporting requirements for ECT. No similar laws whatsoever required for any psychopharmacology, ketamine, TMS, any of the other things that we do. Now, I want to say a little something about the issue of referrals and the so-called chain of culpability. This is actually an issue that is discussed in the Holocaust Museum, where they discuss during the Holocaust how often neighbors would direct the SS and other roundups as to where Jewish people were hiding, and discussed in length in this particular exhibition that I took this from, that those who participated in pointing the finger and saying, over there, go over there to do your dirty deed, that they have a role in the chain of culpability. And this is something that's very important for people who have strong principles of conscientious objection, that the whole idea that you should be able to refer somebody if you don't want to do a certain procedure, that you shouldn't have to refer somebody to someone else who does. If you don't believe that patients should be killed by their physicians, for example, they don't want to be part of a chain of referral that says, okay, I don't do it, but the doctor down the hall might consider doing it. So, and if indeed that patient does end up dying at the hands of that doctor, a conscientious objector would feel they were part of the chain of culpability in bringing about death by doctor. So I bring that up because this is a very significant issue, particularly in both abortion and assisted suicide. And it's come up in several places here in the US. In Vermont, there was a group called Alliance Defending Freedom that actually won in a legal argument against their physician-assisted suicide law in Vermont, saying there was insufficient protection of conscience rights. Turned out it was actually, it was not really a court case. It ended up in mediation, so it wasn't really legally binding. All of these states that you see there had assisted suicide bills, all of which required very explicitly in the law that if you were a physician and you didn't want to participate in providing a lethal prescription, that was okay, but that you were obligated to find the patient or point the patient in the direction of somebody that wasn't a conscientious objector. No guarantee they would provide a lethal prescription, but wasn't a conscientious objector. All of those bills that required such an explicit referral were defeated. In New Jersey, because of inadequate protection of conscientious objectors, there was a temporary restraining order put on the rollout of their physician-assisted suicide law, but ultimately that temporary restraining order was lifted. And those who worry about this continue to feel that there is not adequate protection of conscientious objection for in the physician-assisted suicide law in New Jersey. And just, jumping out of the United States for a moment, this is particularly a major, major issue in Canada. I mean, they are really, really going to the mats on this in Canada. In 2015, just as the country was almost a year away from their law permitting medical euthanasia, the Canadian Medical Association considered at their annual meeting a motion to uphold the conscientious rights of physicians who objected to being part of the chain of referral for euthanasia. It was defeated by an overwhelming majority. The Canadian Medical Association refused to endorse it. The College of Physicians and Surgeons of Ontario basically issued a policy in June of 2016 that effectively said, I'm not going to read this to you, but effectively said that if you do not at least participate in an effective referral for the patient, if you don't want to provide euthanasia yourself, and remember in Canada they do euthanasia, not just writing a prescription that you give to the patient to take at the time and place of their own choosing, but doctors push a lethal injection, just like in Benelux overseas. But the College of Physicians and Surgeons said, if you don't participate in effective referral, you are abandoning your patient and you are being unethical. Well, the number of conscientious objecting physicians sued in the courts, and the courts agreed not with the conscientious objectors. They agreed with the College of Physicians and Surgeons in Ontario. They said that doctors are obligated to give referrals and that so it's not only at this point in Ontario unethical, but it is illegal to not participate in giving referrals. And the court went on in their explanation to basically characterize any stand against participating in euthanasia as fundamentally religious, not about medical ethics. Why? Because the Canadian Medical Organization supports euthanasia. So they turned to the Canadian Medical Organization. They said they don't think that it's unethical. So if you object to this, it must be on religious grounds, and religion has no place in healthcare. End of conversation. I'm going to skip this slide in the interest of time, but it's just testimony, remarkable testimony from some physicians talking about being conscientious objectors to the legislature in Ontario. I'm going to skip that slide as well. I want to just, as we're over outside of the US for a moment, that in Belgium, where most of the practice is euthanasia, there's a small amount that's assisted suicide. There's actually a significant movement among pharmacists there that are refusing to dispense lethal prescription drugs to patients in the interest of committing suicide. Most of the refusals are more likely to occur if it's a psychiatric patient who do have access to physician-assisted suicide and euthanasia in Belgium, as I said at the beginning. All right, let me just focus now on a couple of ethical dimensions about this. Now, obviously, we've been talking a lot about the law, and law and ethics are not entirely identical. Many people consider law sort of a broader area that ethics certainly overlaps, although not necessarily is always consistent with ethics. Many people sometimes refer to law as ethics light. And remember, just because something is legal does not necessarily mean that it's right, that it's ethical, that it's morally acceptable. Remember, there was a time that the Holocaust was legal, and that slavery was legal, and hiding Jews was criminal, and freeing slaves was criminal. So you can't always necessarily turn to what the law says is allowed or allowable or desirable as an index or barometer of what is ethical. Legality is not morality. And yet, as Aaron Kierty at UC Irvine reminds us, laws shape the ethos of a culture by affecting cultural attitudes towards certain behaviors and influencing moral norms, so that there is very much an influence by how one crafts the law on what society starts to believe is morally acceptable. Now, when talking about freedom and conscience, there are kind of two different perspectives one might take. One is the perfective perspective, and the other is the preservative. In the perfective perspective, where freedom of conscience means the freedom to be able to pursue a good, something that you think is desirable. Whereas in the preservative construal of conscientious objection, it is the freedom that we're talking about is the freedom to refuse to do something that you consider evil. There's a lot of talk that the perfective perspective really sets you up for a slippery slope, that the freedom to do good and more good and more good and more good eventually leads to mission creep and the expansion, and indeed an expansion of the definition of what is good. That's why most ethicists tend to prefer, when talking about conscientious objection, that it be deployed in the context of allowing people to refuse what they think is doing wrong. And I think that's something for us to kind of keep in mind, these two perspectives, and that people who think ethically about this really prefer a preservative perspective. But this issue of these two perspectives shows you that conscience rights can cut both ways. In this particular case, just last year, this doctor wanted to provide assisted suicide to a patient in Colorado, but she was an employee of a Christian-affiliated healthcare system that prohibited assisted suicide by its employed physicians, calling it intrinsically immoral. So Dr. Morris informed her employer she was going to do it because she felt it was a good. She wanted to do good for her patient. The health system reprimanded her. So in last August, the doctor took her employers to court and sued for the right to practice medicine according to her individual conscience, which is protected by Colorado law. And at the moment, this case is in federal court. And the healthcare system is claiming freedom of religion. The doctor is claiming freedom of conscience. So here's the problem, in that laws that somehow serve and protect conscientious objection, from one perspective, they can be seen as the protection of one's religious values, cultural values, moral principles. But for those who may object to those particular cultural values and religious beliefs and moral principles, these are seen as license to discriminate, and instead are window dressing and costumes to cover up racism and homophobia and misogyny. So at core here, we're talking about the right to self-determination. And the right to self-determination, the question is, whose right to self-determination? Yes, patients' rights, but don't doctors also have a right? You know, it's actually not doesn't go over well, particularly in public. And physicians and especially ethicists want to argue, make arguments in favor of what are doctors' rights, because we are seen to have our rights subsumed. So I'm going to skip a couple of slides here in the interest of time. But, you know, the question is, if society says, we license you, so jump, we say what rights you have, must the physician say, okay, I guess since you're giving me a license, I have to say, how high should I jump? Or does a physician and medical organizations, do we have a right to articulate the parameters of what the inherent values are to our practice? As this group of very leading and some of the most respected medical ethicists of our era have written, part of the concept of a profession is that it should define its ethics independently of the state, the market, and the vicissitudes of popular opinion. Moreover, professions have a positive ethical responsibility to take public stances on issues that are central to the meaning of their work. So I want to kind of wrap up by sharing with you this very prominent article by Stahl and Emanuel in the New England Journal of Medicine about conscientious objection in healthcare. They say, by entering a healthcare profession, a person assumes a professional obligation to place the well-being and rights of patients at the center of professional practice. In a professional context, personal religious convictions are secondary. But professional organizations should give us guidance. We need to rely on them. It is incumbent on professional societies to affirm professional role morality and authoritatively articulate the professional ethical standards to which all licensed healthcare professionals must adhere. Professional associations should resist sanctioning conscientious objection. They remind us that unlike conscripted soldiers, healthcare professionals voluntarily choose their roles and thus become obligated to provide, perform, and refer patients for interventions according to the standards of the profession, no matter how sincerely held. Objections to treating particular classes of patients are indefensible. However, there is a role for conscientious objection. It's not something that we should dispense with entirely. When? They write, healthcare professionals who are unwilling to accept these choices. I'm sorry, I'm talking from the next slide. I'm going to go to the next slide. However, there is objection. However, there is a specific role for conscientious objection. It provides limited recourse in professionally contested interventions. That is, interventions about which healthcare community is debating whether participation is appropriate or not. And they give as the example of where it's still up for grabs, where we're still debating, where it's not a foregone standard of practice, physician-assisted suicide. But conversely, although abortion is politically and culturally contested, it is not medically controversial. conscientious objection still requires conveying accurate information and providing timely referrals to ensure patients receive health care. So they're not letting physicians off the hook for referrals. So in the end, conscientious objection has a place, and it actually has a place that can actually protect patients. It allows physicians to protect patients, for example, from potentially pernicious emerging social notions that may be emerging in a society. Notions like, for example, because I think this notion is very much packed in to the emergence of assisted suicide and euthanasia, the idea that some lives may not be worth living, or other notions like any pregnancy should be terminated at any time for any reason, or sterilization is a virtuous public good. Allowing conscience rights, especially for institutions, allows us to set up institutional sanctuaries that offer those protections. Asking physicians to just check our conscience at the door for certain procedures opens up the risk of other conscience compromises and integrity that can be sanctioned by working in a system that doesn't value conscience rights. And if you start to close down conscientious objection and tell doctors, if you have a problem, get out of medicine or go into radiology or pathology, we lose qualified physicians who avoid or leave specialties that conflict with their conscience to avoid moral distress. But at the end, there does need to be a balance between conscientious objection on the one hand and conscientious provision on the other hand, because we live in a pluralistic society in which competing values, clashing values, antithetical values, in fact, are the rule, indeed, not the exception. And Lord knows we see that today written larger than we've ever seen before. So conscientious objection and conscientious provision are in a dynamic dialectic with one another. And it is the challenge of policymakers, physicians, professional societies in a pluralistic society that's not reading off the same moral page to be able to strike that balance, to thread that difficult needle. But at the end, as this scholar of the Holocaust reminds us, Raoul Hilberg, at critical junctures, every individual makes a decision, and every decision is individual. Thank you. Are we still together? And I think at this point, I can't hear anybody. So I think most people are muted.
Can you hear me, Dr. Komrad, now?
Okay, now I can hear you. Thank you.
Right. I muted myself. So thank you very much. And we have just a couple of minutes left, I think, before people have to go on to the next parts of their day. But I think this is such an interesting discussion. And I just want to ask you, my impression is that you have spoken out in opposition to, or in support of conscientious objection to physician-assisted suicide or euthanasia especially of psychiatrically ill and otherwise not terminally ill patients. And yes. if I hear the end of your discussion correctly, I'm wondering if you're saying that if the ethical standards promulgated by medical societies or by cultures or nation states such as Canada or yes. Belgium or the Netherlands moves to endorsing physician-assisted suicide for psychiatrically ill patients or non-terminally ill patients, would you be saying that we would no longer be in position to conscientiously object to such requests?
No, I don't. I think that, as I said, ultimately, I think that there is a place for individual conscience. I do think that we need professional guidance. I also think, and this is sort of a whole other topic, which I'd love to come back and talk to you about. I think that there have been many historical examples where medical organizations have actually lost their ethical moorings, swept along by rapidly and remarkable changes in social mores, such as, for example, in our own role as psychiatrists and participation in eugenics, forced sterilization in Nazi Germany, the role of leading psychiatrists in the T4 program to exterminate the mentally ill, the leading edge of the Holocaust. So even, I think, physician organizations can lose their ethical moorings. But I think that they have a role in brokering the conversations, in relying on the legacies of medical ethics that they have inherited, in standing up, and I think it's very important how they do it, in standing up deep dives into the question. And by deep dives, I mean, the AMA has now taken not one, not two, but 3 deep dives through the Committee on Ethics and the Law into the issue of physician-assisted suicide. They have convened scholars. They have convened patients and families. They have gone deeply into the literature, and on 3 separate occasions have considered what their stance is on physician-assisted suicide. And all 3 times, after such a deep dive, they have come to the conclusion that it is not ethically consistent with the role of a physician. Now, in contrast to that is the Royal College of Physicians, and in contrast to that, the Canadian Medical Association and the Canadian Psychiatric Association, none of whom took a deep dive and spent several years and several rounds trying to study. Instead, they pursued their analysis on the basis of polls, just taking a poll, asking whoever wanted to participate in the poll, which tends to be people who tend to have extreme views one way or the other, and they're very sensitive to how the polls are worded, by the way, and that's some interesting research to show how nuanced changes in language can change the outcome of a poll. Just merely asking their members to do a gut check. By the way, the Canadian government did the same thing. They took a poll of their citizens to do, just say yes or no, answer the following 10 questions. Do you believe this or that? Now, in the dangers of a democracy is that you can do those kinds of superficial examinations. So I think that medical societies have an important role to play. It can be misguided in process, and I think sometimes they can reach the wrong conclusions, with which unfortunately only history demonstrates the wrongness of that decision. As we look back now at the way in which the American Psychiatric Association, the German Psychiatric Association endorsed all sorts of remarkable eugenics practices. And, we're thinking, what were they thinking at the time? How could they possibly have endorsed those ideas? Sometimes it takes the long shadow of history to be able to put these things into a full examination.
Can I ask if other members of the group would like to comment? You should unmute yourselves and speak up or ask your questions. We have just a couple minutes left.
I'd just like to say thank you so much for coming and doing this talk. Dr. Komrad already knows these are a lot of my favorite topics. And you all will probably be receiving some follow-up articles from me about some of the things that were touched on, because these are all the things that I've been focusing on in the bioethics part of my life. So thank you so much for coming. I enjoyed this very much.
You're welcome. And the bioethics, I think, is quite important, because talk about people who know how to take a deep dive into things and devote themselves professionally, skillfully. What do they say? I'm a professional. Don't try this at home. And I think that's important. But one of the things that I do want to say, it's a fascinating thing when we're dealing with these topics. You definitely see a divide between bioethicists, medical ethicists who are physicians and those who are not physicians. Physicians who are acculturated in the professionalism of medicine, who have been at the receiving end of medical culture and the legacies, as I say, the venerable legacies of medical ethics, and who are the ones who are in the trenches, working with the patients, the one who are asked to be at the blunt end of the needle pushing the lethal injection, or at the pen end of the prescription to give a patient a chemical gun with which to shoot themselves. And I think that the world looks very different from that perspective. So in the end, when I spoke about balancing or threading the needle between conscientious objection and conscientious provision, okay, I'm really speaking to society there, not physicians. I think we have a right to define and articulate the parameters of what we say is okay. You know, if society says, we want you to do lethal injection on prisoners, we say, no, that's not ethical. Society says, we want you to work on converting homosexuals into heterosexuals. We say, no, that's not what we do. We get to say, and we've been saying for centuries as societies have come and gone, as empires have risen and fallen, what we as physicians will or will not do based on the ethos of our. So if society wants to make a decision to say, okay, we're going to allow some people, not everybody, but we're going to draw a line, and good luck with keeping things within whatever line you draw. We're going to allow some people to commit suicide. We'll allow them to do it by injection. We'll allow them to do it by taking a medication. All right, if society wants to go that way, and I can argue, as I will in a separate lecture, if you want to invite me back, why I do not think that's good social policy, okay? But if society wants to do that, fair enough, but leave medicine out of it. Leave physicians out of it. You know, there were 5 generations of royal executioners in France. Stand up, lay aside. A whole separate, you know, it doesn't take that much technology or training about how to give a lethal injection. Let, you know, thanatologists, executioners do that. You know, let's do it across the street, particularly in the departments of those people whose backgrounds are much more correlated with their favoring these things in the interest of autonomy and so forth. You know, we'll set up the thanatology clinic in the Department of Philosophy, over in the law school, in the Department of Political Science. But you come knocking on the door of medicine, and particularly knocking on the door of psychiatry, where we have a very fundamental ethos that very much revolves around, you know, helping people find a path to a better future, helping people even make some meaning out of suffering, deploying their support systems, finding some other alternative to ending their life as a means of dealing with their suffering. If they come knocking on our door, our ethos invites us, demands us, requires us, I say, to be able to say, we don't do that. That's not what it means to be a psychiatrist in particular, and I want to say physician in general. But if society wants to have ethical provision, conscientious provision, in addition to conscientious objection, then let's stand that up as something that's outside the scope of what we profess as a profession.
I think
so I've clearly gone down that rabbit hole. So excuse me for getting passionate about something that I clearly feel very devoted to.
I think that's a good place for us to stop. So I'd like to thank you again, Dr. Komrad, for spending this time with us and taking us through some of the provisions, some of the history and legislation and discussion around it, and also thinking through some of the ideas and principles that should govern our thinking. Thank you very,
so
very
much.
Thank you.
Thank you.
Hope to meet you all someday
Yes.
in person.
Before everybody gets off, I just want to remind you that at 4 o'clock this afternoon, there'll be a meeting up in our conference room, and I hope you will all be able to attend.
And I hope you all wear masks at that meeting.
So long.
Does Elvira know, or is it a surprise?
She knows. She knows.
Okay, thank you. I can't go, so that's why I wanted to know.
Okay.
Bye all. Thank you.
Bye all.
What's the meeting about? Hi, Peter. What's the meeting about?
Oh, it's to say so long to Elvira.
Okay.
I don't think it's so relevant to you or to Julie, who have not really worked with Elvira, but Elvira is leaving, working with the service.
Okay, no problem.
Okay,
We'll talk later.
bye all.